The defendant's contention that the declarations of delinquency were insufficient to toll the probationary period is not preserved for appellate review. See People versus Douglas, 254, Appellate Division 2nd, 300. 680, New York Supplement 2nd, 351. Affirmed, 94, New York 2nd, 807. 701, New York Supplement 2nd, 305. In light of the fact that the defendant does not challenge the substantive challenge or findings and declaration of the hearing court, we decline to reach his contentions in the exercise of our interest of judicial justice. Inter alia, we do not wish to vacate their default in answering the complaint upon their payment of the sum of $1,000 to the plaintiff. See Island Seafood versus Anchor Fish Distribution, 269, Appellate Division 2nd, 426. 703, New York Supplement 2nd, 216. The record demonstrates that this action was discontinued by order dated March 23, 2001. Since the plaintiff offered no ground to vacate the order of discontinuance, the Supreme Court erred in granting its motion to restore this action to the calendar. See James versus Nadal Corporation, 290, Appellate Division 2nd, 248. 735, New York Supplement 2nd, 533. Campgen versus Underwood, 287, Appellate Division 2nd, 547. 731, New York Supplement 2nd, 657. In an action to recover damages for personal injuries, the third-party defendants, Astra Construction Corp. And Preferred Mutual Insurance Company, appeal from so much of an order of the Supreme Court, Kings County, Sherry Judge, as was entered July 2nd, 202, and as granted that branch of the City Construction Company motion, which was for summary judgment at the time of its making. Furthermore, the defendant, third-party plaintiff, and third-party defendant, 10 Colonial Avenue LLC, thereafter Colonial, hired a contractor to perform renovations in an office building it owned. The plaintiff, an employee of the contractor, was injured while using a table saw that lacked a protective guard to cover its blade as repaired or required by the Industrial Code, Section 2, New York City Law 23, 1123. Contrary to Black and Decker's contention, a sufficient nexus exists between Colonial's alleged liability under Labor Law, Section 215, and Black and Decker's alleged wrongful acts to support Colonial's indemnification claim